Hello, everybody. Welcome to my live for today. What are we going to talk about today? Well, we're going to do a little subset of family petitions, specifically when an LPR, which is a lawful permanent resident, petitions a son or daughter, and things to look for, and traps that people do that they get themselves caught in that, basically ruins the entire petition. So I thought I would do just this little subset of the family petition so that you could be a little more aware of it. Okay. Then what I'll do is I'll go back. I'll see what questions you guys have, if any, on immigration law, U.S. immigration law, that is. And I'll answer them. And then I'll go, do my other consults, okay? So let's begin. So, a family-based petition, you have a lot of different categories, and we're not going to talk about all of them here because I have a specific issue I want to let you know about. We're not going to talk about, number one, if a U.S. citizen is petitioning any of the number of ways that U.S. citizens can petition, okay? This applies only if you have a green card. And it applies only if the green card holder petitions a son or daughter. Okay? That's the only category we're talking about today. Why? Because when an LPR petitions a son or daughter, there are certain things that will happen. Now, first of all, I've defined LPR, lawful permanent resident. Okay? They have a green card. When they petition a son or daughter under immigration law, son or daughter is defined as a single son or daughter, man or woman, over 21 years old. That's the definition. If they're under 21, different category. If they're married, different category. Okay? So, to be clear, we're talking only about a son or daughter who's single over 21. Okay, that is the preference of petition we're talking about. Why do I bring this up? Why this particular category? What makes it so important? Well, I can tell you what's happened over the last 30-some years that I've practiced, which it is 30-some years, soon in the future to be 40-some years. I can tell you what's happened. So you have an LPR that petitions a son or daughter over 21. They wait years and years and years. And then sure enough, the son or daughter gets married and they think they can bring their spouse in to be a derivative, a dependent. What they don't know is the very moment that the son or daughter who was being petitioned got married, it voids the petition like it never existed. And you can't go, oops, and get divorced. You can't go, oops, get an annulment. The very second that son or daughter gets married, the petition no longer exists. And I've had people that have gone for years thinking everything's hunky-dory and now they're going to bring their spouse, their stepchildren, and thinking everything's going to go fine, only to find out that because they got married, they basically ruined the petition. They ended it, terminated by operation of law. Okay? Why is that? You're asking. Because there is no immigration category for a lawful permanent resident petitioning a married son or daughter. No category. There is for a lawful permanent resident petitioning a single son or daughter, but not married. There is, of course, a petition for a U.S. citizen petitioning a single son or daughter or a married son or daughter, okay? I mean, those are different preferences, but there is the possibility. So when I have an LPR that comes in and tells me that they did a petition for their son or daughter, the first thing I need to see is if that petition's still valid. And there's even been cases where the LPR becomes a USC, and it's all a matter of timing. Did they become a USC, which is a United States citizen, before the son or daughter got married? Because if they did, then it'll convert to a third preference petition, that being USC petitioning married son or daughter. Or did they get to become a USC after the marriage? If it was after, the petition's still void, the application. And there's no way to reinstate it. There's no way. No operation of law, no legal arguments, nothing. So if you're going to be an LPR petitioning your single son or daughter, you better make sure that they or you do not do something that ultimately results in the petition being vacated and denied by operation of law. That's why it's important, when it comes right down to it, that you have an immigration attorney that knows what they're doing. Because, to do the LPR petitions, they think, well, LPR petition, USC petition, we'll just wait, get married, have derivatives, and, everybody can come and enjoy the United States. It doesn't work like that. Okay. I've had people who have done this without any knowledge that they've done it. And years later, they find out the petition was void. And when they go in for their interview thinking that they and their spouse are going to be able to easily come in and get the green cards, they're only told, unfortunately, that the petition was vacated, denied, and no longer existed the moment they got married. Okay. Now, this isn't with every type of petition, clearly, but it is with the petitions from the LPR. Okay? I hope I made that clear, because it can get a little convoluted. Okay? All right. So that's that. Let's see if we have any questions. Let me scroll back. All right. So, how's everybody doing on this Thursday? It is Thursday, right? Oh, Seth Patton joined. Seth, I have a brother named Seth. It's not a real popular name. Okay. Let me see. Just a second. So, just scrolling to see if we have any questions. Sometimes we have a lot, sometimes we don't. Just a minute. By the way, Bella got the #1 gifter badge. I usually find when people get the #1 gifter badge, I find that they have a question shortly thereafter, but not always. Just a minute. Okay. Oh, Bella, see, what am I? See, I told you. I knew you had a question. Okay, Bella. Hi, I have my I-130 approved 11 years ago. I have my master hearing in 2 months in WebEx. Okay, so we're talking about two very different things, okay? You're in removal proceedings for some reason, but you have an approved I-130. And the fact you have an approved I-130 11 years ago makes me wonder what the preference of the petition is, okay? Since you've waited 11 years, it's probably a sibling petition, which, and it also depends what country you're from, or it's a petition for married son or daughter, or it could be what we're talking about today, LPR petitioning son or daughter over 21. I don't know. But it's obviously not current, unless it is current and you don't know. So I need to see if you even qualify to adjust, because just having an approved I-130 by itself does not give you legal status, okay? Let's say you're from the Philippines and you file a fourth preference petition for a sibling today. It will not be current for 25 years. So you can't possibly think, because if you're in the U.S. and you file a fourth preference petition from the Philippines, that you're allowed to stay here for 25 years. It doesn't work like that. So I need to know I need to know what the preference of the petition is. I need to know if it's current. I need to determine if you qualify to adjust status. I need to determine if you will qualify to adjust once it becomes current, and if a possible continuation is good. I need to see what other things you might qualify for. Okay? The fact it's a master hearing probably means it's your first hearing. You have to keep in mind that immigration courts are not your friend. The judge is not your friend. The trial attorney is not your friend, especially in today's day and age. The trial attorneys are told to fight everything all the time, regardless if it's reasonable or not. Okay, it's frustrating, but that's how it is. And so you want to have an attorney represent you. Okay, it doesn't matter. It's in WebEx. All that WebEx means is that instead of you being there in person, you're there, via video. It still has the same legal effect. It's not easier. It's not harder. It's the same. Okay, so make sure you get an attorney to represent you to see what's going on. All right, and see if they can help you. It's not like a civil case where, person A sues person B to get $1,000 judgment for, encroaching on their property or whatever. No, this is your life we're talking about. If you get removed, you get removed. And obviously you don't want to be one of those people that says, well, I'll try it myself. If it doesn't work, then I'll get an attorney on appeal. That's not the best idea, okay? Because on appeal, we can only use what was put in the underlying hearings. And if what was done in the underlying hearings is not correct and didn't properly do the things they needed to do, the appeal is going to be garbage. Okay, that's the reality. The time to get the attorney is when you have your hearings in immigration court, i.e. the first master hearing. Okay, all right. Let's see. We might not have any more questions, but I'm gonna see. Okay. Okay. This is from Princey. Hi. Me and my husband are going for the I-130 interview tomorrow. I have an order of protection against him. Well, that's interesting. Okay. On one hand, you have to go to the interview to tell how hunky-dory everything is, that the marriage is bona fide. But on the other hand, he might have abused you. You're in a situation where you really don't want to lie or misrepresent the facts. So if you go to the interview and you have an order of protection, the question is it a bona fide marriage? Are you living together? Or, is he going to the interview just to help you get the green card, which that's not going to be legal. Because if you do have an order of protection, you likely were abused. You likely may qualify for VAWA. So you absolutely don't want to misrepresent things in front of the officer. Because if you go to the officer and you say everything's hunky-dory and they separate you two and it comes out that you have an order of protection against him, they're going to know you're lying. You don't get an order of protection when things are hunky-dory. Now, if you previously got it and you're trying to work things out, you can represent that you had previously gotten it, that now you're trying to work things out, that hopefully everything will eventually, be fine. So you're still showing that it's a bona fide relationship, that you're still trying to make things work, but you're not misrepresenting that everything was hunky-dory. You know what I mean by that legal term, right? Okay. All right. Well, Bella, you put you're married, but if you're married, why have you waited 11 years for the I-130 to go forward? Is it your husband that petitioned you? I mean, the fact you're married doesn't necessarily mean that it's a marriage petition, okay? Princey, should we go? I told the DA I don't want to continue, but final court date after is out, our I-130 date. Okay. Well, Princey, I cannot tell you exactly what to do at this point because I don't have your whole case in front of me and I haven't analyzed it. But based on what you're saying here, you don't have a good relationship with your husband. You have a current court case. You don't want to continue, even though your husband might. And you can't go and lie and misrepresent. So in that case, again, I got to qualify it because I haven't analyzed your case. But based on what you're saying, you should not go, because then you will have abandoned it. Okay. So, I mean, you can go and you can tell them that you're going to be applying for VAWA. But of course, the real issue is is your husband going to be with you? Obviously, you can't. You, number one, don't want to put yourself in danger. So don't go if you're going to put yourself in danger. Because even if you abandon the application, you still, assuming you qualify, can still go for VAWA. And you'd never have to tell your husband, because if you sit there and you tell him, husband, I know I have an order against you, but I'm also going to apply for VAWA, which shows abused, spouses, of which you committed, he might not like that, okay? But under law, they're not supposed to disclose anything. So if you have a bad relationship with your husband right now and you fear certain things, obviously don't go. But you call my office, get started on the VAWA. We explain why you didn't go, why it was abandoned, why you still qualify, okay? All right, Tony, 0707. What's the chances of someone's naturalization process being canceled if they've been detained? Well, a lot, but it depends on the facts. Were you just detained and released? Are you in a criminal proceeding now? Was something dismissed? Was something not dismissed and it's waiting for a plea? Okay, depends. Okay, user with 32 different numbers after it. Is it safe to travel in advance parole DACA? No. I wouldn't do it. Even if you qualify, and even if the law says there's no problem, these ICE officials are violating the law. They're violating the Constitution. They know nothing about the law base. They're basically hiring people who can talk without any other qualification, and they get money for detaining people. So we're not living in a good time. I would not leave if you have advanced parole. What I would do is look and see what you can do in order to obtain lawful permanent resident status. Okay, that might be better. So you're temporarily here on DACA. Who knows when that'll end? You don't have to worry about them deporting you. At least they shouldn't. So see an immigration attorney and find what you qualify for and begin on that. Don't worry so much about leaving the U.S., okay. All right, let's see. Just a minute. Where was I? Because I just scrolled all the way past a bunch of questions. Okay, there we go. Let's see. So, Tony detained by ICE, currently in custody. The citizenship test was scheduled before detention. Okay, well, that's not good. I say you're detained by, I don't know if it's you or, your husband or whatever, spouse, whatever. So the question is, why is this person detained by ICE? I would have had to ask this before, but is there any basis for it? Is it because the color of the skin? Okay, get an immigration attorney to find if it's an unlawful detention. If it's an unlawful detention, there's ways of getting this person out and then continuing with the naturalization. I mean, I don't know why the person's detained. Okay, I need to know that in order to determine. Obviously, if it's a wrongful detention, you're not going to simply roll over and not go for the naturalization. Okay. Jabi, did I pronounce that right? Can I adjust my status if I have passed removal proceedings and come back to the U.S. now with a 212 waiver and a 994? Something doesn't make sense. Jabi. The I-94 is going to only be given if you're a non-immigrant. The I-212 is going to only be given if you're an immigrant. Those two don't match. You can't just come back like that. So I need to know. Oh, I think I know what you're doing. You're thinking that if you do come back with these things, can you just adjust? And no, it doesn't work like that. Okay. Again, you need to call my office so I can see why you were removed, what the deportation bar is, what the grounds of inadmissibility are, and what you might qualify for. If you do qualify for a waiver, if there's a qualifying relative, and then even after all that, if there's a way of adjusting status. Okay, so a lot needs to be analyzed to see what you can do. All right, Tina. Sir, the new proposed law, H.R. 875, DUI, do you think it will be retroactive and affect LPRs? Okay, I don't have every bill that has come out across the United States in my head. I'd need to see what state that is. I'd need to look at it. It shouldn't be retroactive, okay? Generally speaking, when laws are retroactive, they violate the Constitution because you have no notice of what they're doing. So even if it is theoretically retroactive, you can fight that. Okay. All right. Let's see. J-Lo. J-Lo. That's a famous person, huh? Can I still apply for a U visa? Police signed the U certification but stated I did not cooperate. No. No, you cannot. A specific, absolute requirement is that you have cooperated. So the question is, why didn't you cooperate? Is that a correct statement? I mean, sometimes they'll say things that are not entirely true, or you didn't, know you were supposed to go back or whatever. But if you affirmatively did not cooperate, you're not getting the U. Okay. You are welcome, Tony. Okay, and you're welcome, Tina. All right. I think that's going to do it, especially since my actual consult's starting 8 minutes from now. So everybody have a good day. This will do the live for today, and we'll talk again on the next.